that is use of medical marijuana in basically a public place. The felony count, which is carrying a concealed firearm, he was given $1,000 signature bond. So there is a cash or professional bond, or cash bond on the felony count. The state does oppose his bond being reinstated because...
I'm a little confused over the scenario. Walk me through again, I'm sorry. I read your motion, but I didn't look at it. What was the original one? What was the original charges? What is the second? What were those charges?
So
what was that bond?
So in 23 CF 2294,
Right.
in count one is carrying a concealed firearm. He was given $1,000 signature bond on that count.
Okay.
The count two is use
That
of
was a $1,000 signature bond?
signature bond.
Okay.
Count two was use of medical marijuana in a vehicle. That was the ROR
Okay.
that he was given. And in the 24 case, he was given a bond at first appearance. So in the new case, he was given a bond, like Mr. Gilbert
So there were
said.
just two charges, two counts in the original charge?
Correct. That's
Okay.
correct, Judge.
And the new charge was that he got the $5,000 bond was just possession of a controlled substance?
That's correct, Judge. Mr. Cooper does have two previous possession of a controlled substances charge on his score sheet, Your Honor. He got a new charge while he was out on bond. The state does oppose his bond being reinstated at this time.
You making an argument that he's a flight risk?
No, Your Honor, but he's,
Are you making an argument that he's a safety risk?
no, Your Honor.
Okay, then I'm gonna give him a bond. I'm not gonna reinstate the bond, but I'm gonna have, on the the concealed firearm, that'll be a $1,500 cash or professional bond, and the medical use, the second charge, I'll continue being an ROR bond, and then he's got a $5,000 on the new charge. Thank you, Your Honor. Thank you, Your Honor. Okay. Do we have any other private counsel here? No. Okay. Mr. Tony, I'm sorry, Mr. Harper, you wanna try and do some?
Judge, my client is not present. I don't have any.
Okay, that's fine. Is Dayton Greg here today? Would you come forward? Would the state announce this case? Walk up to the podium, please.
This is State versus Dayton Gregg, state case number 22CF1893, here on a violation of probation.
Okay, Mr. Gregg, this is your first appearance on this violation of probation. You do have the right to have an attorney to represent you. If you cannot afford one, one will be appointed.
Yes, sir.
Do you wish to have an attorney appointed at this time?
Yes, sir.
Okay. So the court's going to appoint the public defender. You do have to still fill out the form,
Yes, sir.
you know, for downstairs and whatnot. The court's going to go ahead and enter a denial. It's like a not guilty plea on the violation of probation. So you have a chance to meet with your attorney, and then we'll come back. After that, we'll come back on July 16th at 9 a.m. after you meet with your attorney, okay?
Any other, Mr. Gregg can fill that out before leaving today.
There you go. That's good. That's all you need. Any questions? Okay, just meet up with your attorney. He's got your card right there.
Thank you.
Okay, thank you. Okay. So is Nicholas Gamillion here? Would you come forward as well? Would the state announce this case?
Yes, Judge. This is State versus Nicholas Gamillion, 23 CF 519. He's charged with marijuana possession, not more than 20 grams. and improper exhibition of a firearm.
This is a violation of probation, is it not?
That's correct. I apologize, Judge.
Okay.
This, yep.
I'm sorry, go ahead.
Judge, can I have a moment with probation? The recommendation here was if he's completed his community service work and all remaining conditions, that probation would recommend termination. Has he done that in the time since the?
Let me look that up. I know he's past term.
Okay.
Let me email his, computer and then email his officer.
Judge, my understanding was that he hadn't completed that. One moment. The offer in this case would be to revoke in term and send all remaining cash obligations to a lien.
You need any information from probation?
I'm looking at it.
It might be best if we pass this case, because if he was able to complete those obligations, then the VOP would have just gone away.
Okay. Let's just hold on, let's just stay with us for a few minutes, we may be able to get everything resolved.
You know, I mean, just a thought, we could always ask Mr. Goodman if he's completed those obligations.
Because I do not see anything in our computer that would verify that those have been completed.
Okay.
I talked to my probation officer, Prophet. I talked to him before I came here. I talked to him, actually called me into his office Tuesday. They tell me, he said, just show up. We're supposed to be getting terminated. He said, you owe a little bit more money. He said, just pay the money you owe. After that, he said they're going to terminate you. But you still owe a couple money, a little bit of money.
Okay, so what you're saying, your probation officer told you you completed everything except for the money?
Yeah, he said, I owe a little bit more money. He said, but it's going to get terminated. He said, but if you don't pay it, your license will get suspended. I was like, yes, sir.
So, Judge, with that in mind, the offer would be to revoke in term and send anything remaining to collections.
How much is owed?
Judge, I believe that'd be a question for probation.
I'm looking
Kim,
at that.
thank you.
No one- Could we extend a little bit and give them a chance to pay is what I'm thinking of. I don't know what's worse, being on probation or having your license suspended.
Well, that's fair, Judge. I think
Maybe the worst punishment is to not be able to drive and not be able to work.
He owes, Your Honor, $977.60.
he's past term, Judge, but what I would say is we could continue this and that would give him the opportunity to go ahead and pay that money.
How long do you think it'll take? I know it's not an insignificant amount of money.
I do security and I just got a new job for vacation aid. And basically, I ain't gonna do my security because I've been on probation, so my security license got suspended until I get off probation. So that's the only reason I ain't been able to pay it off, because I just got a new job. Like,
So it'd be better for you just to go ahead and terminate probation and
yeah,
then
I'll
put
be able
it,
to go back to my good job, yes, sir.
okay, but they might end up suspending your license.
It's gonna get bad. I'm not trying to have this. I'm trying to get this done with. Cause I got charged with another charge in Mariana. I got charged with marijuana. I had a marijuana card as well, and that finally just got dropped. And so now I'm just waiting on this so I can get back to work.
And you know, just so the court's aware, it was a misdemeanor and a withhold on the misdemeanor. He was placed on probation.
Right. Well, I'm trying to be cooperative. You've worked to try and do it. You've fulfilled everything. You just haven't paid up the money and you haven't been able to work because of this. So I'm good. What were you suggesting, counsel?
Well, Judge, we would revoke and terminate and send all outstanding monies to a lien.
And I would say, normally, if this was just my case, I would revoke and terminate and give, say, 24 months to pay those outstanding fees.
That would be fine with me, Judge.
Okay. I'm going to revoke and terminate. I'm going to split the difference. I'm going to give you a year,
Okay.
12 months. You can pay this. I think you can catch it up in 12 months.
Yes, sir.
Okay. Very good. Any questions then? So we'll revoke and terminate,
No,
but it will go to collections, so it'll be on the collections record, but you gotta try and get that paid off because they'll come after your license,
I can
okay?
still just pay it the regular way through correct pay. Or
That's a question I don't know. Where would he pay it after his term, after his probation's been revoked? Would he pay it with the clerk? Yes?
sir.
Okay. So just pay it downstairs at the clerk's office. They'll tell you, where.
Okay, thank you.
And I think the clerk will probably want to, are we adjudicating or are we maintaining the withhold, just for the record?
We're maintaining the withhold of adjudication. Okay? That's good, you're good.
Okay.
Thank you,
Yes,
your
sir.
excuse. Thank you, Mr. Gates.
Yes, sir.
Okay. Mr. Harper, when your client arrives, just wave at me and I'll get you, break you in. Ms. Farkas, you're next up with your
Sure.
crew. You wanna go, or you wanna let Mr. Gates go? It's up to
I
you.
do have an out-of-custody client, Sheila Connor.
Okay,
She could approach. I have a couple out-of-custody clients, actually.
okay.
We'll start with her. This is Sheila Connor, 2020 CF 0056. This was a notice to appear, if I could approach with the agreement.
You may.
and a brief explanation.
Thank you. Thank you.
Your Honor, this was a notice to appear in the underlying case. It took the state and the defense a year to reach the restitution amount. So probation is simply asking that the term of probation be extended a year to allow her to continue paying back that amount. So the VOP will remain a withhold and just extend the probation by a year so she can continue paying the restitution.
And what is the amount of the restitution? Do we have that identified? Is this not, I don't see it
The
here.
total amount of restitution was $46,069.21.
Does that need to be contained in here?
I can add it if Your Honor would like.
I mean,
It's already been ordered, Your Honor. I'm sorry, Judge. Yes, it's already been ordered, I think.
if it doesn't need to be, I'm not trying to just add something here, but I just want to make sure we're.
There's already an order in probation, had it on the violation report
Yes.
that she has been making payments.
Okay.
So I believe that we know the balance of what is owed.
Yes, the balance is $34,917. Ms. Connor has been making the minimum and sometimes more, the
Okay.
payments every month, so there's no other allegation that she violated anything, just that it's a lot of money and she needs time to keep paying it.
Absolutely. Okay. So the state's in agreement with that?
Yes, Your Honor, that was the state's agreement.
Ms. Connor, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, so you heard your attorney state the terms, and it's in the written plea agreement that you signed. So you understand we're extending this, you're admitting the violation of probation. They'll continue with the withhold of adjudication. Obviously, that's an important consideration for you. Reinstate and modify probation to extend for 1 year from the original termination date. So the new termination date will be July 22nd, 25.
Yes, sir.
Okay? Complete all original terms of probation, plus, of course, they always get you with additional fees and costs.
Yes, sir.
But main thing is the restitution. That's the big one they're looking for. Okay? Any questions concerning that? You understand that it'll be a final resolution. You're waiving the right to go to an evidentiary hearing. That's in you've gone, add all your legal questions answered by your attorney?
Yes, sir. Yes,
Okay.
same probation officer, Officer Whitworth?
I believe so. But I can't,
She will report to our office, we'll prepare the paperwork, and then we'll send her back, yes.
okay. So just go to probation after this. They'll walk you through it. I'm not 100% sure they'll have the same probation on it, but they'll let you know when you go over there.
Okay,
Okay?
okay.
Okay, thank you very much. Any other questions?
No, sir, thank you.
Okay, thank you very much.
Next I have Wade Downing, 2022 CF 2407. Your Honor, this is a VOP. Mr. Downing entered a denial, and I met with him last week to discuss the case. I do have an offer from the state attorney, but I would like to continue it for another cycle to continue negotiating. And then I do have a question about the ankle monitor. Mr. Downing is on an ankle monitor. If there's any way that we could reduce the cost to the minimum, if the court could order that, I believe it could be reduced to $1 a day.
State,
No objection to that.
but we'll reduce the cost of the GPS to $1 a day, and we'll continue this matter until July 16th at 9 a.m. Okay, stay in touch.
Thank you, Your Honor.
And what are all the numbers to go on the 16th and 11th?
Christopher De Silva? Your Honor, this is Christopher De Silva, 2022 CF 1699. This is the first time the VOP is up, I believe, unless we were assigned after the denial was entered. So,
Denial has been entered.
Okay, thank you.
I believe so, correct, yes.
so I was just recently assigned the case, if we could continue it to the July date.
Okay, we'll continue this to July 16th at 9 a.m.
Thank you, Your
We'll
Honor.
meet up with her in the interim, okay? Thank you.
I believe that's all of, oh, I'm sorry, I also have Luis Flores. 2023 CF 367.
You have an email with a PD, please step out to the hall.
I believe that the state has an announcement in this case, unless,
Your Honor, the state will be dismissing the violation of probation in 23 CF 367.
Very good. You're good, thank you. You're excused.
So does that mean,
I'm sorry?
you dismiss, reinstated probation, terminated probation?
No, they're withdrawing the VOP. That's what I heard him say.
he's past term.
He's passed term.
He's past term, so it's automatically terminated. Thank you for that clarification.
And those are all of my out of custody clients.
Okay? Mr. Gates, you want to do any out of custody?
Yes, Your Honor, I do. I will take, looks like 3 right now. And the first I'm going to call is Richard Harter, H-R-T-E-R. Mr. Harter is before the court in 23 CF 2802. At this time, if we can enter a denial on the violation of probation, and ask that the court continue the case without subpoenas.
Very good. The court will deny this matter and we'll continue this until you want to just go a month out.
Yes, Your Honor.
Sufficient. Come back on 7/16 at 9 a.m.
Thank you, Your Honor.
All right.
Thank you.
Your next I've got is going to be Angela Jernigan. Ms. Jernigan's making her way up in 21 CF 3111. We have a plea agreement to be filed in Ms. Jernigan's case.
Thank you.
Your Honor, it's stated as squishy later, but it's not going to be downward departure on Ms. Jernigan's case.
Very good. Would you announce the agreement?
Yes, Your Honor. It's going to be, Ms. Jernigan's going to be admitting the violation before the court, maintain the withhold, terminate probation, standard cost of prosecution, public defender fee, and then she'd ask for 24 months from today to pay those outstanding fees before they're sent to collections in the civil court.
State?
That's the state's agreement, Your Honor.
And the restitution also will be sent to Ali as well?
Yes, Your Honor. We're going to give her time to pay, if, as much, 24 months to pay those before they're sent to Alani Collections.
Okay. It just says court costs, and I just wanted to make sure the
Yes, sir.
restitution is contained. I know it's a picky, but
Yes, Your Honor.
just trying to be clear. Okay. Sir, ma'am, would you please raise your right hand? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
Okay. You heard your attorney state the terms of your plea agreement,
Yes.
and I see those are written out and you've signed it. So have you reviewed this closely, and just want to make sure you've gone over it with your attorney?
Yes,
Had all
sir.
your legal questions answered?
For as the payments, do I continue to pay through JPay or?
Clerk's office will
Okay.
make those arrangements.
Okay.
Right.
Well, that's the only question I have.
Okay, that's a good question, because that's what this, unfortunately, this is all about payment of fees and whatnot. And
Correct.
that's not the kind of thing we, unfortunately, we have to deal with, but it's not our favorite item. But you understand that you're waiving the right, you could go to a hearing and all that on
Yes.
this. You believe this is in your best interest to enter this plea agreement?
Yes, sir.
Okay. Court will accept your plea agreement. The court will maintain the withhold of adjudication, so that's a benefit to you. Court will terminate probation. There'll be $100 cost of prosecution, $150 public defender fee. and you will have 24 months to pay any outstanding court costs, including the restitution, before they're sent to collections. Okay? After 24 months, and the reason why, it'll give you a chance to pay it before they go after your license.
Okay.
Okay, so try and get that paid. You've got a good little bit amount of time to pay it, but, you know, try and make it a little bit at a time, so you don't have to get overwhelmed at the last minute. Okay?
Yes, sir.
Any questions?
No, sir.
Thank you.
The clerk's office. Your next I've got is gonna be Charles King. Mr. King should be before the court in two cases. We have 12 CF 2366 and 20 CF 674. If I may approach with a plea agreement, Your Honor?
You may. Thank you. Would you announce the agreement?
Yes, Your Honor. Mr. King will be admitted to violation before the court. He was previously adjudicated guilty. In 12 CF 2366, we're going to revoke and terminate probation. Standard cost of prosecution, $150 public defender fee. The outstanding court costs and fees and restitution are going to be rolled over into the other case, which is 20 CF 674. I have a bit of scrivener's error in that I say 22 CF, it should be 20 CF 674 on that second part. Modify and reinstate probation. Count 1, which is the felony count, we're going to extend his current supervision by 24 months. We're going to waive the cost of supervision. Count 2, which is misdemeanor, we're going to do time served. Again, standard cost of prosecution, public defender fee, and the state's agreed to an automatic early termination upon payment of the outstanding court costs, fees, and restitution.
And that's the state's agreement, Your Honor.
Very good, thank you. Sir, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, Your Honor.
So you heard your attorney state the terms of your plea agreement. You just want to make sure you've gone over it with your attorney, had all your legal questions answered?
Yes, I have, sir.
You understand that you had the right to go to a hearing on all this, you're waiving that in order to get a final resolution?
Yes, Your Honor.
Which is understandable, it's a good resolution. But you do understand, just want to make sure you had all your legal questions answered by your attorney.
Oh, I have, sir.
Okay.
Thank you.
Very good. Based upon that, court will accept your plea agreement. In case number 12 CF 2366, the court's going to revoke and terminate probation. You've got the cost of supervision, the public defender fee, and all other costs and fees and restitution is going to roll over into the other case. The other case is 20 CF 674. On that case, we're modifying and reinstating probation. Extend probation by 24 months. So starting now, you got another. So are we extending, are we starting now for another 24 months, or are we extending it? We're extending it the way it's worded. So
yes, sure.
When is it scheduled to end, just approximately? This is not a.
Yes, sure. The probation was scheduled to end next week, actually.
Okay.
So we can either extend.
So it's just a little over the 24.
He terms on 6/21, so we want to extend from the end date.
24 months. Okay, I just wanted to make sure you understood. It wasn't clear when it was being extended from.
Sir, I have one question.
Sure.
Will probation be terminated once I meet the restitution, pay it off completely?
The state, as a part of this plea agreement, the state has agreed to automatically have early termination upon payment of all outstanding costs, fees, and restitution. So once everything is paid, yes.
Yes, Your Honor. Thank you.
Okay. So, and that's part of it, so I just read it out. You'll get, on count 2, you'll get, that was the extending it for 24 months was on count 1. Count 2, you'll get credit for time served. Those are done. Okay?
Thank you, Your Honor.
Okay. Any questions?
No, sir.
Okay. Thank you. I'm sorry? 30 days. You'd have 30 days to appeal this if.
Okay.
Even though you just agreed to it. Okay. Those are all your out of custody?
Custodies that are ready for it this time, Your Honor.
So. Is anybody here that thinks they have a hearing? What's your name, sir?
Cedric Beecham.
Mr. Beecham. That's Mr. Medina's case.
It is.
Yes, Your Honor.
We'll wait for Mr. Medina to come back. Is that also Mr. Medina's case?
It is.
All of them are Mr. Medina's?
I know Mr. Beecham is Mr.
Yeah, they are here for an inmate. She is with Mr. Medina, Mr. Beecham is with Mr. Medina.
Your Honor, if I may,
No.
Okay.
Don't say anything before your attorney gets here. Just wait for him. We'll get him up as soon as he comes. Okay. So we want to start bringing out inmates?
We can. I'm ready for it.
Let's do it. No time like the present. You got the most anyway, Mr. Gates, I think.
Herder, Dickens, Johnson. This is going to be Ms. Celeste Johnson before the court.
Who is this?
Celeste Johnson, Your Honor.
Okay.
23 CF 1459.
Hold on just a second. Okay. Yeah, thank you.
And Your Honor, we have a signed plea agreement. While reviewing and talking with probation, it appears that there's still an outstanding order to take into custody pickup order from Ms. Johnson. What happened is she was arrested on May 30th. The first appearance judge put out a pickup order. It was never served on her, so technically it's outstanding. However, the plea agreement we have will resolve the violation of probation. So if the court can recall that order or pickup order, that'll keep her from being arrested when she shows up to probation to check in.
State.
That is correct, Your Honor.
Okay. Court will withdraw the pickup order.
Thank you, Your Honor. If I could approach.
You may. Thank you. You can pull Mr. Tony's client up, which is, you want me to, do you have that? I got it. No, it's Flores, Andre Flores. He's out of custody. Okay, thank you. That's why he's not in. I'm sorry.
That's all right, Your Honor. At this time, Ms. Johnson is going to enter an admission to the violation before the court. She was previously adjudicated guilty. We're going to modify and reinstate her probation, required to complete the original requirements, standard cost of prosecution, and public defender fee.
Okay, state.
That is the state's agreement, Your Honor.
Okay. Ms. Johnson, would you raise your right hand, please? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, so you heard your attorney state, you can put your hand, you heard your attorney state the terms of your plea agreement. It's in writing here, you've signed it. Just want to make sure you've gone over it with your attorney, you understand what you're doing, because it does have some legal implications. You're modifying and reinstating probation, there's additional costs and fees. So have you had all your questions answered about this plea agreement?
Yes.
Okay, I mean, it's pretty straightforward. It's a
Yes.
simple plea agreement, but I still have to ask, because you have a right to go to a hearing on it, and you're waiving that. Believe that's in your best interest?
I believe this is in my best interest, yes, sir.
Okay, so the court will accept your plea agreement, and you were previously adjudicated guilty. The court will modify and reinstate your probation. You have to complete your original requirements, and of course, they always do the ever-present additional costs and fees on you, which we have no control over. So it's a $100 cost of prosecution, $150 public defender fee.
Yes, sir.
Okay? Any
Addition
questions?
to the 800, right? Okay, yes.
Okay, and you should be able to get out there, I think.
She's got some misdemeanors holding her in,
She's
Your
got some
Honor.
other things. so-
Yes, Your Honor. As far as this case is concerned, she would be eligible for release.
Oh, wow.
Spoke too soon, sorry.
Okay, good, okay, thank you.
All right, good luck, Celeste, okay?
Okay, thank you.
Question?
I was just saying, I emailed the warrants recalling.
Thank
Your Honor, this is Mr. Ashton Hardy. He's on the morning docket under 23 CF 2709. He's also on the afternoon docket under 24 CF 1059.
That on the,
On today's docket, yes, Your Honor. Yes, Your Honor.
Hold on, so let me get that. Okay, got it.
Your Honor, at this time, we're going to enter a denial on 23 CF 2709 and enter a not guilty plea on 24 CF 1059. If we can schedule both cases for August the 14th, which is when his pretrial is scheduled.
Very good. The court will enter on the VOP, will enter a denial. Is that all right? I think it may have already been entered. But if not, we'll enter a denial on the VOP, which is 23 CF 2709, and the new charge 24 CF 1059. Court will enter a not guilty plea, and we'll come back on both of these on 8/14 on the pretrial.
Thank you, Your Honor.
Okay?
And for court security, he can go back. He doesn't need to be held.
Yeah, it doesn't have to be held for this afternoon.
Your Honor, this is going to be Christopher Higgins before the court in 23 CF 896, 23 CF 2064. At this time, Your Honor, we're going to enter a denial on the violations of probation. If we haven't already, we're looking at getting Mr. Higgins into drug court.
Okay, so we'll enter a denial on both cases, and we'll come back on just as a status on 716.
Yes, Your Honor.
Okay. Hope you can get into drug court. It's a good program.
I think she's not going to see again, okay? All right, Mr. Higgins. And that's all the inmates I have at this time, Your Honor.
Mr. Tony, you ready to go?
Yes, Your Honor.
Good morning, Your Honor.
Good morning, Mr. Tony.
Your Honor, may I approach?
You may. Thank you. Okay, thank you. You can get that. Thank you. Mr. Tony, would you announce the terms of the agreement?
Yes. With regards to the state of Florida versus David De Jesus Flores Andrada, pursuant to negotiations with the state attorney, Your Honor, the state of Florida and I have agreed upon the following sentence to be opposed as a condition of this plea. Adjudication will be withheld as to count 1, adjudicated as to count 2, misdemeanor domestic battery. He will receive standard probation for 24 months. The court cost will be $515. He's to have no violent contact with the victim, and the other sanctions would be 1129 probation for the misdemeanor domestic violence to run concurrent with the 24 months of probation.
Okay. Let me make sure. I'm just a little bit confused. I just want to make sure I'm reading this correctly. So, count 1.
It's tampering with the witness, Your Honor. It was
Okay.
typed in the wrong.
Okay. Count 2 is the domestic violence battery.
Yes, sir.
So, what is, what is the sentence or what's the agreement as to count one?
Standard probation for 24 months.
So both of them will be, both counts will be the 24 months probation?
Well, the one is it's the misdemeanor domestic violence, so it's only 1129 probation, but they're to run
Got you.
concurrent.
Okay, got you. Okay, that makes sense.
This is on.
Okay. Mr. Flores? So is the state in agreement with that, or is that, do we need clarification?
Well, it appears to be, yeah, we're going to need clarification on it because
Sure.
it's my understanding there would be no violent contact because
Uh-huh.
the couple is married, but it's the state that requested to be no contact.
Well, that means you all haven't come to agreement. So have you spoken with the victim?
Your Honor, the victim has not returned the state's phone call, which is why, at the moment, we're not going.
Okay, why don't we do this, Mr. Tony? Why don't we pass this over? I hate to have to come back, but I don't think that's an important point. We can come back on July 11th and try and deal with that. I'm not going to.
What we could do, Your Honor, is go ahead, enter the plea today, and then have the victim make the request to the state and to the court to have have the sentence modified.
If the victim would request that there be contact, is the state amenable to that?
The state would agree to that.
Yes.
Okay, so we'll enter this, and then if you all by stipulation agree to amend it based upon that, I'm fine with that. You just have to make sure, kind of remind me of it, paper it, when you send me the proposed stipulated order.
Yes, sir.
That, this has been done, the state's in agreement, blah, blah, blah. Okay?
Yes, sir.
Okay. So, Mr. Flores, would you raise your right hand, sir? I need to ask you some questions. Does he speak English? You speak English?
No.
No. He doesn't speak English? Does he speak English?
Habla inglés? No.
No. We need to make some, let's see if we have the interpreter in the building.
So we may be coming back on the 11th then.
It would be, no.
Only one in the house is Portuguese.
Portuguese. Okay, let's continue this till July 11th. And you just make, I don't know, who does he contact to make arrangements with the interpreter?
Board administration, I think.
Board administration. Okay. So, July 11th, to make sure he understands it.
Your Honor, may I approach on another matter real quick?
Sure. Do we need to have the state?
Yes.
Mr.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays, 10 until 3 p.m.
For years. Okay, July 11th. Make sure he.
See you then.
Thank you. Your Honor, I have 3 or 4 out of custody. Would the court wish for me to?
Sure.
Them?
That'd be great.
I think we maybe should do Beecham last.
Okay.
So let me call, if I may, Tevin S. Austin. Mr. Austin is 22 CF 1598.
Good morning, Your Honor. Okay.
Your Honor, my understanding from speaking with my client is that all probation requirements have now been complete. I had been expecting that he would get some proof from JCS that would show that, or that they would file some sort of a document, but they did not do so, and I've reached out to JCS to see if they can provide some sort of a proof, but I think we need a control date, and it may go away if JCS will file proof and the state can give notice of dismissal of the VOP or something like that. We may be able to take them off the docket.
The state, any input?
Or we could, hope that Ms. Ferlin responds back later in the morning or something, and, but I just.
You can always bring it back. I mean,
yeah. I think it'd be better to get a control date, and,
sure.
and I may be able to get some.
I think it'd be better to have a control date now and give us some time.
So we'll continue this till July 11th at 9 a.m.
July 11, okay, you got that?
Yes.
So it may go away, but unless you talk to me and I say it's dismissed, then you need to come then, July 11 at 9 a.m.
Yes, sir.
Thank you. Thank you, Your Honor.
Okay.
Thank you, Your Honor.
You're welcome.
Your Honor, next is Justin W. Manios. Mr. Manios is 21 CF 777. And, Your Honor, my understanding is that this was basically his probation runs out today. He has financial obligations outstanding. He says he works 7 days a week and has community service hours are outstanding. So he's asking for a continuance so he can try to get everything cleared up. Could we have something like a 2 or 3 month continuance? Because it's a substantial amount of money. It's just court costs as far as I know. Well, it looks like cost of supervision too. It looks like around $2,000. Does that sound about right? $2,000. So I don't think.
When do you want to try and come back?
I would say maybe September ideally.
That's okay. Is the state okay with that?
No, I'm fine with that.
Okay.
Okay.
So we'll continue this until September 17th at 9 a.m. Okay?
Yes, Judge, and I'm putting in my card so that once he completes everything, he can let me know, and maybe we can get it off the docket or something. So.
Okay. Sounds good.
Okay, but you're on that. What was that? I'm sorry, Judge.
September 17th, 9 a.m.
Thank you, Your Honor. Okay, thank you. Your Honor, next is Valerie S. Perez. Ms. Perez is before the court in 20 CF 1286. At this time, she would like to deny the VOP. Let's keep it on. I'm sorry.
I've got 3 cases.
There are 3 cases. I'm sorry, Judge. I just picked up one of the files. Right. There are 3 cases.
Let's announce all 3 of them.
Right, Judge. Let me get the other case numbers.
So I'll call them out.
Thank
18
you,
CF 2796, 20 CF 1286, and 21 CF 2912.
Thank you, Your Honor. I have all the cases files in my office, but I just brought one. I apologize.
Right.
So she would like to deny the VOP in those cases and have it just set for non-evidentiary. Just I know it goes in the docket as VOP evidentiary, but without subpoenas. And she and I will get together. And does the state have a recommendation?
There's a 36-month suspended sentence in the event of a violation.
So is the state going to be asking to execute the suspended sentence? Okay. So, Your Honor, can we just have the next VOP evidentiary a month or two from now?
So are we going without subpoenas?
Without subpoenas.
Okay.
But
So
she needs, it'll take her some time to meet with me and figure out what we're going to do.
That's fine.
We may
Is July 16th a good, is that sufficient time?
I think I'd rather have a little time because we may have to look.
You want to do it in August?
I'd rather, because we may have to
Okay.
look at inpatient treatment application type.
We'll come back August 15th, does that work?
Yes, Your Honor.
August 15th. So we'll deny all
Got
the
that.
VOPs. We'll come back August 15th at 9 a.m. without subpoenas.
Okay. All right, so set up an appointment, okay, as soon as possible. Thank you, Your Honor. Now, my next one, Your Honor, is Mr. Beecham, Cedric Beecham.
Hold on just a second.
Yeah, does this court see the docket? It's 25 on the docket, I think, or 28?
29.
29, I apologize.
Okay.
Your Honor,
Okay.
Steve Medina with Cedric T. Beecham in 20 CF 856, 20 CF 1938. Those were the two VOP cases, and 22 CF 2923. I put this on for a status, and it was, at the time, based on trying to get some direction of the court as to whether we should put the motion for a correction and or clarification on a special docket. And then after that, I had a conversation with Ms. Sharpless, and she also wrote an email that she was not opposing the motion, more or less. It wasn't being contested by the state, and that the state thought there was a resolution. Meanwhile, because under the literal wording of the sentence, the DOC sentence, it was 3 consecutive 1 years, and I pointed out in the motion that he was literally entitled to credit for time served under the express wording that was an issue. In fact, he got released. I don't know when he got released. It was
DOC released me yesterday.
DOC released him. So at this point in time, I think it's a complex situation. I just found out about his release, and I talked about it with one of my colleagues, and I have to take a position in my client's best interest that has to do with him maintaining his freedom and being on 2 years probation, because my position would be, I can argue it later, but it's that there was a 2-year suspended sentence, and in essence, it's been served. It's been executed and served. Therefore, only thing left was
my understanding of your position is you're acknowledging that there was a mistake in the sentence, but because your client's been released, you're not going to allow that sentence to be corrected? That's what I understood you. I'm confused about the whole thing. I'm not disagreeing with you. I'm just saying I'm confused. I just want to, that's what I think I heard you say.
Well, what I want to say is, Your Honor, I need to research the issue.
Okay.
And meanwhile, he is out. I think it should be clear he is under probation. We can disagree or agree on, should be under probation right now, because there was, at a minimum, a decision of the court that he would be on, at least under the new law case, which has time. The court issued a 1-year DOC followed by, with respect to the new law case, it was going to be 1 year probation. So the question is it really 1 or 3 years or 2 years? And we can make argument on that. I'm not trying to disrespect the court or be a bad officer of the court, but I have to advocate for my client's freedom. I think it's my obligation. So I would ask that it be...
I don't know that it's your obligation to argue for your freedom if you know that there was a mistake made.
Your Honor, if
I don't know. No, this is not yours. This is a legal argument, Mr. Beecham. I don't want to engage. You're very well-spoken and you've got a position.
well, I got some statutes.
Mr. Beecham?
Yes, sir.
I do not want your involvement in this. This is a legal matter. I'd ask you not to speak.
I got you.
Okay?
Your Honor, so my intention.
I'm not clear what the mistake was or whether there was a mistake. I'm not clear about whether or not the mistake was in the into the order that was done, or versus that I made a mistake in the proclamation, or whether there was a misunderstanding. I'm totally confused about why we are here.
So, Your Honor, the issue that Mr. Medina brought up, and he had case law to back that up, was because the total probation and DOC ordered in the 220 CF cases was a total of 4 years. That because it included probation, that exceeded the 24-month suspended sentence, and the 24 months suspended sentence was supposed to have been the max. So the state looked at his case law, did some research. That's correct. So that does need to be fixed, but it's clearly the court's intention. And when I looked at the order that was issued, I'm unsure why it was calculated where he was released, because the court clearly stated in its order that was signed that it was to be 3 years of DOC total, and that the 3 counts were consecutive to each other. So I'm unclear why he's been released. So I have a solution that I think will work, that will result in the court's intention, which the court was very clear. The court wanted 3 years DOC followed by probation. However we got there, the court wanted us to do that. I have a resolution. Clearly it was the court's intention for him to be incarcerated for 3 years, and I would like to resolve this today, because clearly it wasn't the court's intention for Mr. Beecham to be released. And I would like for that, the state would like for this to be resolved today. If we can take this up this afternoon. I have a solution.
Your Honor, may I respond?
I'm just to be honest with you, I'm still not clear. I mean, you guys are assuming I haven't even looked at the sentencing order.
Right.
I'm not clear about what the issue is.
Right. Yes.
I'm not disagreeing with anybody. I'm just saying I don't understand what the issue is.
The second issue in my motion, Your Honor, was time served. And that I was anticipating this kind of disagreement might come up. What I didn't want to have happen was, the reason why I filed my motion, as soon as I got back from my 3-day vacation after we had the sentencing on, I think it was on a Tuesday, on Monday, I think I filed Monday morning this motion because I researched it. I think it was on Monday, right away, because what I didn't want to have happen was him to have to go off to DOC and be disadvantaged by coming back and losing gain time or something. But basically what the second part of my motion was that under the literal statute, he's entitled to his time served.
After literal statute, what do you mean?
Under the statute of the state of Florida, the language, when you're giving a sentence, you're entitled to the time served on each of those cases. So that I was pointing out that he is entitled to all his credit in all 3 of those cases. He has basically had a year and a half in, and that on each of those years should be given the year and a half by statute under Florida law.
Unless it's specifically stated otherwise in the plea agreement. That's my understanding.
If it was not a plea agreement.
Not, okay.
But, Your Honor, in the court's order, it does let DOC know that the court's intention was for these to be ran consecutively. So the court's order made it clear that it was going to be 3 years total DOC. So yes, he's entitled to the 18 months he's already done. But it's the state's position he should not have been released. The court made it clear it was going to be 3 years total. And that's what the court also stated in court.
And is that not what the sentence says?
It says consecutive, and it makes it clear, Your Honor, that it was to be 3 years total DOC.
And then it says the box is checked, if I'm not mistaken, on the order of probation. The box, or then the judgment, or whatever the paperwork is, it's checked that and it's shown in the clerk's record that he was entitled to credit for time served. And then when DOC sees that, they look at it under Florida law that if you apply that time served, it applies to those 3 cases. That he gets all the jail credit in each of those cases. So he met it. DOC.
So the state doesn't disagree with that. I didn't. Where is the state disagreeing with how the jail calculated the time served? I'm still not clear what the issue is.
Your Honor, he should not have been released under the court's order, I don't think. So
Who made the mistake? The jail who calculated and released it? I don't know.
Your Honor,
You're saying that you agree he should get credit for time served. He has a year and a half in.
Your Honor,
the ruling was consecutive sentences, 3 years, so he shouldn't have been released. Am I hearing
Your
you
Honor,
right?
I think the way that this, and I think that the sentence structure that was put to the court is confusing, and I would like for that to be corrected today. But it was clearly the court's intention in the court's oral pronouncement of the sentence and the court's order that he should complete 36 months of DOC. So I think.
Is that not how the order?
It says 3 years total DOC, and it says they should be run consecutive to each other, Your Honor.
The order says 1 year on 1 year on one case, followed by 1 year on another case, followed by 1 year on another case, and it also
isn't that consecutive?
Yeah, yes, but it also says with credit for time served, and DOC correctly applied the statute, which is Florida law, which is obviously binding, and it correctly released him because he had the 18 months or so credit, which is applied to each of those 3 cases.
So, Your Honor, the state's proposition is that a new order is entered and that the court on the 22 CF case where there was 5 years of jurisdiction, order 3 years of DOC, followed by 2 years of probation. But on the 220 CF cases, order 1 year probation each on those cases.
So
concurrent with each other, but consecutive to the 22
I understand
CF
the fix.
So,
I understand the fix, but what I don't understand, I'm still trying to I'm still going to wrap around what the position is of, who calculated the time served? The jail?
The jail does how much credit.
I understand. I'm just trying to
and
figure out.
And then DOC applies the statute to it.
Okay, so DOC. I'm just trying to figure out who I'm.
DOC released him.
DOC's position, we did 3 years consecutive. 3 consecutive 1 year terms, right? For a total of 3 years. That was the purpose. And are they interpreted that as all the credit for time served
applies to each case, I guess.
Applies to each case.
Yes, that's what they did. I haven't seen their paperwork, but I think that's how they applied the law. And that was the second thing I pointed out in my motion.
I might be able to clear up this confusion.
I'm open to your.
We received from the prison who calculates the time. Mr. Beecham on the 20856 case, he had 674 days.
Because he had prior credit on that.
The 2020-1938, he had 551 days credit. And on the 22-2923, he had 551 days credit. They did an emergency release yesterday because he was over his credit for time served. So they did an emergency release, and that's why he was released yesterday. So he is now, according to what I see, on active probation.
Well, and Your Honor, the state's position is that clearly the court's intention was for him to not just do 365 days total. The court's intention was for him to do, I think, 365 times 3 is 1,000 and something days.
But in each case they had credit for time served on it, on each of the 1 year. Each of the 1 year.
So, Your Honor, that's why I was suggesting, because this is complicated, and it was set only on the morning docket, and Your Honor's office is, very strict with us. We couldn't exceed 10 minutes. So I was saying maybe we should put it on specially set, and he should be under the probation order that is in place.
I would like to get this corrected today. I think that we can do the court's intention, and the court can issue a new order, a new amended judgment, so that it makes it clear that he's to do 365 days. And then we can do we can do 36 months DOC. I'm sorry, I said 365 days. But I think if the court issues an order today that he is to do, on the 23 CF case, he's to do 36 months followed by 2 years probation, and then do
Well, you're asking to correct we established the sentence.
We did.
The sentence was the sentence that the state requested.
Well, Your Honor,
and I understand what you're saying now, well, that wasn't really our intent, but if that's what was stated and that's what the court issued,
well,
you're asking me to change the sentence.
Your Honor, the court asked us to, and then Mr. Medina pointed out that it exceeded I did not know that probation counted towards exceeding the 24-month suspended sentence. The case law that Mr. Medina provided to the court is correct, but it clearly, we need to, Your Honor, it was the court stated its intention and said to the parties, however we need to get there, please structure it. So I guess that we need to correct that what was issued is not, it exceeds the suspended sentence, and we clearly, what has occurred is not within the court's intention.
Okay.
So.
And I just was saying, judges, I don't know standing here.
I'm not going to make a decision on it today. I appreciate the state not wanting this gentleman who they believe should be incarcerated to be out. But I think there are some issues, and I think.
Your Honor, can we approach, please?
No, put it on the record. We're on the record. What do you got to say? If you want to approach, I'll allow you to approach.
Yes, please.
I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalware. We're located at 648 North Wilson Street. Call 850-682-2446.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Cyclone Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Pretrial Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1055
888-848-5845.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents.
I'm sorry. Your Honor, so the outcome is that we will coordinate with Your Honor's judicial assistants for a to-be-determined next court date for.
Right now, there's an outstanding motion for clarification or to correct. The state can, oh, sorry. Ms. Sharpless?
Yes, sir.
Right now, the current status is there's a motion for clarification or to correct the sentencing error. This is before the court.
Yes, sir.
If you want to file something, I mean, obviously you'll respond to that. But if there's any other issues that need to be raised, they can be in, and we can all deal with them all at one time.
Yes, sir. I understand.
And we'll set it in the afternoon, set about an hour. But, we may need to get a transcript of that sentencing hearing.
Also,
Yes, sir.
may I, one other thing for the record I need to put on the record. Mr. Beecham is indicating dissatisfaction with my counsel. It is not my intention to take any further action on this other than setting a court date. If he's going to file a Nelson motion, he needs to go hurry up and do it, because otherwise we're going to get a court date set. I'm going to prepare for it and do the best I can. But if he has some dissatisfaction with anything I have done so far or might do in the future, he can file this motion. Thank you.
Thank you. Thank you.
Thank you.
I'm good.
You're good.
Your Honor, can I readdress my case? It'll be real quick.
That's all right. Yeah. Take your time.
This will be Chelsea Anderson, number 6 on the docket, Judge. Present and approaching. She is before the court on 22 CF 2811. We're going to enter a denial at this time. One of the recommendations is for her to seek admission into an inpatient treatment program. We're going to use the time to do that, Judge. So if I can set this for the next miscellaneous without subpoenas.
Okay, we'll do that on July 16th at 9 a.m. without subpoena.
Okay. Thank you, Judge. That's all I have to.
Thank you very much.
Thank you so much.
Okay, Ms. Farkas, let's go. Want to go? You want to go? Let's go.
Are we starting with the males or the females?
I'll bring the female.
Your Honor, I think Laquetta Carter will be first.
Very good.
I can start with Ms. Fair, that's okay. Your Honor, first is actually going to be Miranda Fair, 2022 CF 3146. I've spoken with the state and with Ms. Fair and Ms. Fair's parents who are here, and we would like to continue this case to the July date. I believe that we'll be able to resolve it on that date.
Very good. We'll continue this till July 11th at 9 a.m.
All right, thank you, Your Honor.
And has there already been a denial entered on that?
Oh, no, I apologize. We could enter a denial.
Court will enter a denial.
Sorry.
When was that set for, Judge?
I'm sorry?
When was that set?
July 11th.
July 11th, yeah. Thank you. You guys got to pull those mics down. Right? Is this Miss Carter?
Yes, this is Laquetta Carter. Your Honor, I apologize. This is Laquetta Carter, 2024 CF 1044, and, which is on for arraignment this afternoon, I believe, or
In
this
addition
morning.
to today?
Yes, and the VOP,
Okay.
which is 2023 CF 1265. Ms. Carter also has a misdemeanor case that is part of the basis for the VOP. I've spoken with the state attorney, and we reached a new plea agreement, but Ms. Carter and I need time to discuss it. If she could plead not guilty and enter a denial in the VOP in the new case, and we could continue the date to the July date.
And do you want to enter a not guilty on the?
Yes,
new
Your
law
Honor.
charge? Okay.
If the new law could track the VOP, if that's possible. Because I think that everything is going to be resolved in one.
Is July 11th sufficient time?
That would be great, thank
We'll
you.
enter a not guilty plea in 24 CF 1044. And we'll come back on the 11th of July. And then on the VOP, same thing, we'll enter a denial. Well, there's evidentiary. I think there's already been a denial entered, but we'll enter a denial if not, and we'll come back on July 11th.
Thank you, Your Honor.
Okay?
Thank you, Mr. Kessler.
Thank you.
Your Honor, this is Sean Chaplin, 2020 CF 292. This is a VOP. I have been in contact with the state attorney about this case, probably kind of excessively. And the state attorney asked that we continue it to Tuesday, June 18th, for hopefully it will be a resolution on that date.
Yes, Your Honor, I am looking at something, and I think we can work this case out if we can just have.
So in the morning without subpoenas?
Yes, Your Honor.
Yes, Your Honor.
6/18, June 18th, 9 a.m.
Thank you.
Hopefully we don't have too many that are continued until next Tuesday, because we're already
I think I only
pretty
have one.
full up.
I only have one more.
Okay.
Your Honor, this is Stephen Copland, 2023 CF 1395. I just received an offer in this case, which would include a combination of community control and inpatient drug treatment. If we could continue to the July date, that would give my client time to apply for the treatment programs and for us to discuss the offer.
Very good. So we'll enter a denial, I assume,
Yes, Your Honor.
and we'll come back on, we'll continue it until July 16th at 9 a.m.
Thank you.
July 16th. Without subpoenas.
Thank you.
Doherty?
Your Honor, this is Patrick Doherty, 2022 CF 2970. Similarly to the earlier client, the state and I have been in constant contact about this case. If we could put this one on for June 18th, I'm confident we will resolve it then.
As long as you promise me you're not going to ask me for any more dates on July 18th,
No.
June 18th.
I promise you I will
Are you
not.
entering a denial, counsel?
I believe a denial has already been entered.
Okay, very good. So we'll continue this matter until June 18th at 9 a.m. without subpoenas.
Thank you, Your Honor.
Next, Mr. Figure.
Next up is Leroy Figures.
2024 CF 1084, 2023 CF 1120, and 2023 CF 1390. The 2024 case is on for arraignment today. I apologize. I just had them all bundled together.
Yeah, you just did. So, hold on.
I apologize.
Okay.
So in the 2024 case, Mr. Figures would like to plead not guilty. And if we could continue everything, obviously this is the arraignment for the new case, which does change the VOP situation.
So you,
Information has not been filed on the new case.
okay. So we need to continue this to another arraignment date, which will be July 11th at 1:30. That's for another arraignment. Hopefully the state will get something filed or dismiss at that point. And
I guess we
why don't
could,
we just track all,
Yes.
because it's the new law charge, we'll track everything together. We'll track the two VOPs also to July 11th as well. And that July 11th, which is weird, it'll be at 1:30, but because we'll track them all together.
Mr. Figures.
Thank you. Thank you. So those will be at 1:30, Madam Clerk, rather than 9. So track all three of those together.
Your Honor, this is Donald Ferguson, 2023 CF 445, and which is the VOP. He has a new law which is on for arraignment. 2024 CF 1069.
Did we do Jamal Ferguson?
No, Your Honor, if we could address that after.
Okay.
He's in another entity.
Okay, that's fine. I know we skipped over it, and I just wanted to make sure.
Yeah, that's okay, sorry.
Okay. So what are we doing on Ferguson?
So I believe a denial has already been entered in the VOP.
Yes.
The new law, this is the arraignment, so if we could
this
plead
isn't
not
the
guilty.
arraignment.
I'm sorry?
This is not the arraignment. This is,
The 2024 CF
so
1069.
there's a new law charge? Okay.
Yeah,
I was on another case.
that's okay, I'm sorry about
Let me
that.
go back to that. Okay. So what are you wanting to do, counsel?
Enter a plea of not guilty and continue the case.
Okay. And when do we want to continue them to? Do you want to go to the pretrial on the new law charge?
Yes,
or-
I think that makes the most sense. As the new law, I'm gonna need to schedule depositions and speak with the state
So
attorney.
that'll be 8/14, continue to 8/14, and we'll run the VOP with that also on 8/14 at 9 a.m. So both the VOP and the new law charge will be continued to 8/14.
I'll come talk to you. Your Honor, Jamal Ferguson was not transported. He's being held at a different jail. I've spoken with Michelle Sandler. She's handling this case in conjunction with Mr. Losco. She has requested that we put it on for next week, if there is space available on the 17th or the 18th.
You broke your promise.
I know. I forgot because
Judge,
he wasn't produced.
The state would ask to continue it until next week, and then her promise will be intact. My understanding is that Ms. Sandler and the defense counsel have some kind of an agreement worked out where this needs to be moved to next week.
6/18, 9 a.m.
Thank you.
So what's your next case here? Are you done?
Yes, Your
You're
Honor.
done?
Those are all my cases for the morning.
And Judge, that was Ferguson, right?
That was Ferguson.
Okay.
Mr. Gates, you want to do your inmates? I'm sorry?
Is it finished? Would you have, Mr. Medina's inmates?
I've got one here that, Kimmel Lane?
Jordan Kimmel number?
Yeah.
I don't see Mr. Kimmel present.
I don't have any.
Oh, I see. He's not an inmate, is what you're saying. Okay, well, let's go ahead and do Mr. Kimmel, even though you're trying to avoid doing Mr. Kimmel. Did the state announce on this case Jordan Kimmel?
Yes, Your Honor, I apologize.
'23 CF 659. Mr. Kimmel appears not to be present. What is the state wanting us to do?
The state will ask for a capias, Your Honor.
Any legal objection?
No, Your Honor, I was permission checking with me. I don't know, but I think there may have been an admitted affidavit out as well.
I'm sorry?
I couldn't remember if there was an amended affidavit filed. I've got one that was, this wasn't, Your Honor.
You think it might have made it for a different date? Is that what you're saying? Is that?
No, Your Honor, I thought there may have been an amended affidavit, including a new, I'm looking at the clerk's minute sheet. I don't see anything after May.
While you're looking at that, Richard Lane, has that been resolved, that motion for Buchel's well?
Judge, we spoke about this
I
yesterday.
thought you might have mentioned it.
The state's withdrawing its motion based on the defense's response.
Okay, very good.
Yes, Your Honor, and I was appointed in court on the 16th with Mr. Kimmel. He was given a court date today. We'll know how it looks like. For whatever reason, those were sent out after that for May the 16th on the 21st of May. So he might have got confused, but I can't speak to that, Your Honor.
So there was a second one for May 16th?
He was in court on May the 16th.
Oh, he was in on May 16th.
Given today's court date according to the clerk's minute sheet. However, 5 days later, another notice was sent out for May the 16th. So I can only tell the court that Mr. Kimmel's not present.
And you haven't been in communication?
He's not.
And if you were, you couldn't tell him, right? Court's issued a capias.
Yes, Your Honor.
Okay, so that's all of Mr. Gates. Mr. Medina, you want to do a couple?
I'm ready to do my inmates.
Inmates?
However the court wishes to proceed.
No,
I think
we're
the
good.
Female's ready to go.
Okay.
Or do you want to take a break after
No,
the
let's
female?
do it. This is all, I think you're the last.
It's not going to take that much long to do everybody. Let me just get a box. I just got to grab it. I'm sorry, Judge. I just got to move my box over here.
Okay.
Your Honor, Sky H. Brewer is before the court in 24 CF 641. I have not had a chance to speak with the state about her suggestion or request that the state consider community control resolution. This is, as I understand it, a first violation. Does the state have a recommendation? I know that there was a language in the VOP report saying that she needed bars to bed Phoenix House. She has some family situations where it would be her request to do some sort of a reinstatement to the community, and community control was her suggestion.
Why don't we continue it so that you and I can discuss a resolution.
Do you think if we held her over to the afternoon, we could maybe reach one? It's a first violation.
Sure.
It's just technical.
Yes.
Your Honor, would the court permit her to come back at 1:30?
Sure.
Okay, all right, we'll try to work it out this afternoon.
If it's not worked out by this.
Thank you, Your Honor. You're going. Your Honor, I don't know that, I don't have a file for this gentleman. It's Anthony Dwayne Allen. I don't know if he's a public defender client. I didn't have a file for him.
He's got your name on it. I mean, it's on my docket. You are counsel.
Okay, Judge, I'm sorry,
It's a violation of probation. It's the first time up.
Yes, sir.
does the state have an offer? This is Anthony Dwayne Allen.
Correct.
Okay, just there. Okay, sir. Just see what she's saying. Okay. Thank you.
The underlying charges
Yes, Your
are
Honor.
possession of a controlled substance and driving on a suspended. That's the underlying charge. I don't know what the violation is based on, but we can get some clarification.
If you'll give me just a moment, Your Honor. I apologize.
Okay.
And I think he's basically representing that do you have to have surgery? That he has medical issues that could impose a significant burden on the taxpayers of Okaloosa
Your Honor,
County.
Mr. Allen has a guidelines offered. The guidelines appear to be 16.8 months in the Department of Corrections room.
Your Honor, based on that, I know that he will not want to take a DOC offer today, and he can deny the violation. If we could set it without subpoenas for maybe July, and maybe we can get a resolution quicker.
Continue this till July 11th. That's the first date in July.
And as soon as I get a file, I'll come see him. Thank you.
Okay, thank you.
Next is Mr. Bergeron. What? Oh, did you? Who's next?
Should be Bertram.
What, he said Bergeron was.
No, Bertram. Daniel Bertram.
This is Mr. Bethune, but we can take him. Will you get his parents? You don't want it? They're in here. Okay. Your Honor, Steve Medina with Reginald L. Bethune, 23 CF 2580, 23 CF 2582, and 23 CF 2581. Your Honor, we're here on a motion to compel and a corollary motion for bond reduction. He's asking for a signature bond. His situation is such that he doesn't even have money to put on his account at the jail, so he's asking for a signature bond. The finances of his situation are such that he could not meet the $27,500 cash or professional bond. In our dovetailed motion to compel discovery, we set forth very many, if that's the proper grammar, but basically quite a few significant issues on discovery, such as crime scene photographs and so forth. And all three cases have significant issues. I can't prepare for his case without having those materials. I would ask for the court to allow him to make a brief presentation of the testimony on the bond issue, not talking about the facts of his case, but talking about his family situation. Once the court allows me to do that, the state may want to address something first.
Let's let the state.
Your Honor, I have, I know that there was body camera that he needed. I have possession of some more body camera. I am requesting the stuff from Fort Walton Beach Police Department that I can get for Mr. Medina that he's asking for. So as far as the motion to compel, the state doesn't have an issue with an order being entered on those discovery items, Your Honor. We do have depositions set. We are working this case, Your Honor. So the state would just, in summation, ask that his bond remain the same.
Okay, and you want to argue on the bond?
Yes, could he testify briefly?
The court will, with this, state's basically in agreement on the motion to compel, so the court will grant it by stipulation.
Thank you, Your Honor. May I proceed with a brief testimonial presentation on the bond?
Would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Would you state your full name?
Reginald Bethune.
Okay, and with us in the courtroom, are these your elderly parents and your sister?
That's my sister, my mother, and my father.
Right, and your sister is the only person that they have to help with them when you're in jail?
She's taking care of them.
Okay, so what do you want the court to be able to consider about why you need to get out to help your parents, or anything else you want the court to be aware of?
Well, the main thing is to try to get out and help my parents, because, I mean, they like 83, 84. And my sister, she doing all she can by herself. And I just like to be there to help her. I got a job when I get out. I don't, have to worry about a job.
Do you typically provide care and support for your parents?
Well, when I be out, I help them. She do most of the care, most of the work.
Okay. But they do need you?
Yes, sir.
Okay, now let me ask you to address your financial situation. Are you able to are you able to post a $27,500 cash or professional bond, or any cash or professional bond?
No, sir.
Is there anything else you wanted the court to be aware of other than you're not talking about the facts of your cases? Anything else you wanted to say?
No, I just like to get out and just help my parents. That's all.
And are they having health issues?
Yes.
What are their health issues?
The
judge doesn't want us to get into diagnosis, but they have a lot of health issues that they, okay.
Like high blood pressure.
That's okay. I'm sorry, that's nothing further.
Ms. Schultz.
Your Honor, these are very serious cases, and we've previously had a bond hearing, and I let the court know that in two of these cases, the victims are the same, Your Honor. So he's victimized a person twice. Your Honor, the state's requesting that his bonds remain the same.
May I respond briefly, Judge? Because he does have a cash or professional bond, and it's purely a matter of finance, I do think that it is appropriate that he be given a bond that he can meet, which is not able to post as cash or professional. I do want the court to please be aware that based on the accusations, I'm not trying to minimize anything on the accusations, but these were not accusations pertaining to anything occupied. These were unoccupied accusations, and I would like to have him come back for court on towards the next pretrial date. And in the meantime, I respectfully request that he be out on a signature bond. Thank you.
Are there any conditions, Ms. Sharpless, that would allow the public to be safe, such as house arrest or no contact or GPS?
Well, I mean, honestly, Judge, no, because he continued to victimize this person multiple times, so the state's position is no.
Your Honor, I just respectfully, the characterization of victimization, I don't think there was any accusations of anything personal. This was, as I stated, accusations of burglarizing unoccupied dwellings.
Ms. Sharpless?
Your Honor, he went to the house 2 different times, damaged the dwelling in the process of burglarizing it, or the allegation. So yes, a person has been victimized twice. He continues to do things while he's out in the general public, so the state's contention is...
So did he commit a crime when he was out on bond?
Your Honor, he was arrested on November 18th in all 3 cases, I think. I don't think he was out on bond.
I don't think so, Your Honor, but I'm checking that. I don't believe so, Your Honor.
So he's been in jail for basically 6 or 7, 8 months, and we don't have this basic discovery yet.
Your Honor, he does have discovery, he just doesn't have additional things that he has the offense report and he has body camera. There are 1 or 2 additional videos, but those videos are getting to him. Your Honor, he has deposition dates. We are working this case. It's not like the case is not being worked, and the court has denied a motion for bond previously in this case.
And I did not mean to say that the state hadn't filed discovery exhibits, but there are significant, outstanding, major pieces of discovery. I'm not saying they're in the immediate possession of the state. They are under the control of the Fort Walton Beach Police Department, and they're critical to preparation for depositions. We have in good faith set these September 18 depositions, but I can't really represent my client effectively without them. I can't go over significant evidence issues with my client and so forth, so I don't think it's insignificant in any way. And basically, when he had his first bond motion way back in December, he had only been incarcerated a month. And here we are, I'm bad with the math on this kind of thing, but it's roughly 7+ months later, and we still don't have major pieces of evidence. And I'm not saying it's the state attorney's office fault, but it is critical to his preparation. Thank you.
Court will grant the motion. I'm going to move these to signature bonds with pretrial services requiring him to be on house arrest and have a GPS monitor.
You think, Your Honor, will the monitor have to be imposed before he's released from jail?
Yes.
Okay. You understand?
Yes, sir.
And he'll have to maintain regular compliance and coordination and communication with pretrial service, okay?
Yes, sir.
And Your Honor, is there also a no contact and no trespass?
Yes.
Okay. Thank you, Your Honor.
And people will take any violations of these conditions very seriously, and they won't mess around. They'll immediately hook you back up.
Yes, sir.
So take them serious.
Your Honor, I think house arrest, if he works it out with pretrial services and finds gainful employment, they would probably allow him to go to work.
I'm open to that.
Right.
If you need to put that in the order.
So basically, house arrest with approved work exceptions, basically.
Right.
They would have to be approved by JCS. And Your Honor, is his next court date going to be August 12th?
Yes.
Thank you.
Thank you.
This is Mr. John A. Brothers Jr., Your Honor, before the court in 23 CF 2771. Your Honor, he was wanting to make a straight jail offer to resolve this violation of probation of 6 months jail. Would the state consider us discussing that and holding him over to the afternoon if the court permits?
No.
What's this, it's state
The
advised?
state's offer is going to be guidelines. He was placed on 6 months community control. He previously violated probation. I believe it was on 4/11 he admitted to VOP. He's on community control now and has violated community control, so the state's going to ask for guidelines.
Can the state tell us what the guidelines would be
The
approximately?
guidelines are
Because
Mr. Medina, I misread my note here on the score sheet. He actually does not score.
that's what I was thinking, maybe he didn't score.
The state will ask for 1129 OCJ.
So. Your Honor, he's indicating that he will take 1129 jail for a deal today, so it will take me a few minutes to write it up. If we can hold him to the afternoon, that may be most efficient for the court's schedule.
Okay, so we'll come back at 1:30 this afternoon.
Thank you very much.
Thank you.
Hold till 1:30?
Yes, sir.
Mr. Brush?
Steve Medina with Daniel D. Brown. Mr. Brown has a VOP 24 CF 387. I wanted to advise the court that my understanding is that Nathaniel D. Brown also has 24 CF 1219 set for arraignment on July 11. That's 24 CF 1219. I do not know if the state has a global offer that would encompass that. I do not know if we have an information on that new law case.
The information on the new law case. 12/19. 24/12/19.
Your Honor, the state does not have a global offer to resolve this VOP today.
The information has not been filed in the new law charge. Mr. Medina, the information has not been filed in the new law charge.
Your Honor, my client is asking to be able to address the court. I'm not proposing that he do that, but I'm not, I don't know that I'm permitted to restrain my client from speaking to the
Please
court.
raise your right hand. Do you swear or affirm the information you're about to provide this court is the truth, and nothing but the truth, so help you God?
Absolutely, sir. Yes, sir.
And I'm not advising that he discuss his cases or make this statement, but
I understand that, Mr. Medina, and I appreciate that. Your Honor, I would like to resolve everything right now and ask you if I could please go into drug court. I have lost my family.
Mr. Brown, let me explain this to you. I don't mean to cut you off. When you talk about resolving this today, there's only two ways to resolve these matters. One is by a plea agreement. And just hear what I'm saying. An agreement is an agreement between two parties. And the two parties are the state, not the judge, the state and you.
Well, she's listening.
Listen to me. If you all can agree, there'll be a plea agreement.
Can she listen to me? Maybe it's favorable to her.
They don't want it. They said they didn't want to do a universal plea agreement today. Did I understand the state? You weren't offering a plea agreement today?
Your Honor, the state has no plea offer for him today. The 21st date on the new offense is not even up. I haven't looked at it, so I have
Okay, so
no
they
offer.
are not prepared to offer it. The other option that you have is to go to a trial, and we can get this thing ready to go to trial. They're not ready to go. Believe me, I know this is frustrating. It's slow. We all want to move. We want to get things done. They're not ready. I can't force them to make a deal. Even if they made a,
And Your Honor,
I would never do that. That's their option to even offer a deal.
I can't plea out to the judge? Me and my lawyer just asked the judge?
Absolutely can.
Okay.
I am not advising that he plea out on the VOP without a negotiation with the state and knowing what the state's position would be, which we do not know. You could be placed in peril up to the statutory maximum, so that would be against my recommendation. Moreover, there's a case that he couldn't plead to the bench on anyway today, this open other separate case, 24 CF 1219. So if he does that, it would be a very bad mistake, plus it would not be for sentencing today.
If you plead, that's right, that's what I was going to say. If you plead today, say you pled to the court today, just let the court make you plead guilty.
I believe you're a good man, Your Honor, and you make the right decision.
Yeah. Well, that's all well and good until I make the wrong decision. I'm not trying to be cute about it, but I appreciate that you have faith in the judge. But,
Sir,
but
I should have never got on. I should never.
Listen to me. What I'm saying to you is, listen. If you pled today, we would have to set this out for a sentencing in the future.
Like next week? I'm fine with that.
No, it's not. No, it's not. We don't have space next week.
Is drug court the most rigorous program that you guys have? Because I need a rigid.
Your Honor, I'm just advising him. I'll get him evaluated.
I need to speak to the judge, Your Honor. I have lost everything. I'm not asking you. I'm asking you to listen to me, please, Your Honor.
Okay, go ahead.
I've lost everything this year. I've lived on the streets. I've died 3 times. I need to get my children back. I need to send them money. Drug court, I heard, is the most rigorous program. A suspended sentence, drug court, and the Jada House is what I'm asking for. What I pled on probation, I had an empty syringe. They said I had a gram of heroin. I wanted to get out of jail. I'm talking to you, Your Honor. Please listen to me. This is all that I pleaded out to. I get out on bond, they give me fleeting loot on a bicycle. It's not a real charge. They got me with battery on a Leo because 3 cops jumped on me and my leg wrapped around the cop. I never battered any Leo. I never did any of that. I can't win. I need to change my life. That's all I'm asking for.
And the best way is going to take some time to get to qualify for drug court. Hey, I'm a big advocate of drug court, okay? But I can't force to be accepted. You have to be accepted into drug court, and they have to look at it. So Mr. Medina is, you may not think he is.
I know he's a good man. I got no problem with him.
He's listening to you. He knows, I don't want to speak for Mr. Medina. I suspect that Mr. Medina also has a high regard for drug court. and he will try and see if they can get an admission. If
I'm
they're an
done
admission,
with
that may
drugs.
work, that may be a perfect solution.
Never been to rehab, none of that stuff, man. I'm done with it.
Give him a chance to do his job. We'll come back, you know, on this case, on the 11th, it's the soonest date we can have, the 11th of next month, and hopefully we can have a resolution. And if you can get a resolution before, which I don't think you can, it takes a little while to get accepted into drug court. And go through paperwork,
Your Honor,
everything moves slowly.
And I'll come see him and discuss. Now, we have the bigger picture. I'll come see him again very soon. So basically, he'll be on the 9 a.m. July 11. He's also on the 1:30 arraignment, so we may get things resolved on the morning.
But he's not on the arraignment today, is he?
No, Your Honor, not until the 11th.
Yeah, on the 11th.
I was saying the court would put the VOP on 9 a.m. on July 11th.
Is there any way we can move it 1 week sooner? I need to get money to my children, Your Honor.
What I'm offering, it suggests that if there's a resolution that can be worked out before, your attorney can try and reach out and we'll see if we can get it on. But we don't, you know, it's unlikely you're gonna get anything done sooner than a few weeks from now.
I'm asking to plead, last time I did that and took care of 2 cases, just to.
Okay.
Courtroom. We'll do the same things. Your Honor, I don't mean no disrespect to nobody.
I understand. Let's come back on the 11th. Let's see where we're at. If you want to plea out on the 11th, we'll accept your plea, okay?
Thank you.
Okay.
Judge, may I be excused for the morning?
Sure.
Thank you.
Would you like, anybody else want to leave? I've got 2, Mr. Medina.
Right, Bergeron and Bertram. I don't know if they're
very good.
Yeah, Bertram was out of custody, and Bertram refused.
Bergeron refused?
Yeah. I've got 2 inmates that have got pleas.
Your Honor, right, man?
I can take them out before it's got time, we're gonna do it.
For like this afternoon's please?
Yes, Your Honor. The jail, or court security saying that they can be longer than we do now, we can get left, but let's take a breakdown, we'll be back till 30.
May
I mean, we can do them now. I mean, I was kind of pushing through without a break this morning. I don't want to push through quite as hard if we've been sitting a lot this week. Let's do yours. Yeah.
I'm sorry, Judge, just for the record, with respect to James R. Bergeron,
24 CF 404.
Right, and he's also on the afternoon docket today in 24 CF 1061. He also is on the July 11 docket in 24 CF 1184.
Well, if he's on this afternoon, let's hold him over to this afternoon. If he
I
doesn't
think
show
he's
this
refusing.
afternoon,
Well, when they go up there, they can make an attempt, I guess, to bring him up.
oh, I see what you're saying. He refused?
He didn't transport from what they're telling me. He also didn't come up and meet with me when I tried to meet with him
He
day
did
before
not?
yesterday. He did not come up in the
So
jail to
what-
meet with me day before yesterday.
Okay, I was thinking he just, I didn't realize he refused.
So, Your Honor, I don't feel like I can enter a denial or a not guilty plea without my client's presence under the circumstances, because he hasn't communicated anything to me especially, so
Let's see if he wants to come up this afternoon. If he doesn't, we'll deal with it this afternoon and figure out what to do. State can make their recommendation.
I think everything will just end up getting continued over to July 11th, but he has a right to appear, and I can't really take a position under the circumstances.
What about Bertram?
My understanding is Mr. Bertram is out of jail. I would ask I'll try to find him. And if we could just not issue capias, let me try to locate him between now and this afternoon. Could we hold that capias issue open until the afternoon?
Okay.
Thank you.
Okay, so the only thing we got left, you want to do a couple there, Mr. Gates, and then we'll take a break for lunch?
Full security, we can handle this afternoon. They can extend the lunch break.
Okay. I think we deserve to have lunch at least once this week, especially because I've got it 12:30, so I probably won't have lunch.
So when they transportation come up here, the program is out of custody.
We'll reconvene. I've got the pretrial detention at 12:30, so.
Thank you, Your Honor.
Thank you very much.
All rise, please. Court is now recessed.